back in with item 7A1, the appeals of 1930 Stewart Street, D4476. If we could get a staff report.
Good evening, Commissioners. Haka Mordezai, staff attorney for the record. This case is decrease petition number D-4476. It's filed by Belinda Van Sickles, who is a resident of Mountain View Mobile Home Park, a mobile home park that's owned and operated by the City of Santa Monica. In this case, the hearing officer granted a decrease of $86 and reduced the MAR for this unit from $348 to $262. The decrease was for reduction in laundry facilities, loss of yard space, damaged landscaping, reduction in common area landscaping, reduction in management services, community bathroom facilities, paved pedestrian walkways, and the elimination of propane delivery services and a scratched mirror. The city filed the appeal, and the city is urging reversal of various items, and I will go through them. The city is requesting reversal of the $10 decrease for the reduction of the laundry facilities because it contends that it has reinstated 24-hour access to laundry facilities and noticed the tenants accordingly on November 11th, 2010. That date is after the date the record was closed for additional evidence in this case. And since the evidence is not part of the record, it constitutes new evidence. As we've discussed before, consideration of new evidence in an appeal by the board would violate due process. It deprives the other party of the opportunity to respond to the evidence, and it deprives the hearing officer of the opportunity to consider and weigh the evidence and its credibility. And the board should limit its review of evidence to the evidence in the record. We will see this in some of the other appeals as well. This ground, therefore, should not serve as a basis for reversal of the hearing officer. And instead of requesting the reversal of the hearing officer, a landlord who says that they have complied with an issue that was, for which they had received a decrease, they can have that removed through compliance verification process, which is a separate process that's run through the hearings department. And my understanding is that has already occurred with some of the items in this specific case. The city also requests reversal of the $10 decrease for loss of propane delivery services, and it stated that the cost of the delivery of the propane was built into the cost of propane, and that the city's only involvement was to provide the resident information to this third-party delivery service provider. These statements are new evidence, which was not submitted to the hearing officer, and the board therefore should not reverse the hearing officer based on this new evidence for the same reasons I mentioned before. The city also requested a reversal of the $1 decrease for the scratch mirror, the $10 decrease for the loss of the community bathroom 24-hour access, and also the loss of on-site management services because it said that it had corrected those deficiencies, but that was after the record had been closed. And once again, that's something that should run through the compliance verification process and not a reason to reverse the hearing officer. That's essentially my report for this specific case.
Thank you, Haka. And we do have one request to speak in this item. Belinda Van Sickle. And just to let you know, you get 3 minutes to speak, and just a second, I'll turn your mic on. 10 minutes? I apologize. You get 10 minutes to speak. Okay. There you go.
Well, I would like to agree with the staff report and also offer some information regarding what the appeal is stating. The city has, the landlord has stated that they have, in fact, reinstated some of the things that I received a rent decrease from the hearing officer from, and in fact, that's not the case. And because they brought these things up after the hearing was ended. And let me let you know that this was a 2.5-year process, a 2.5-year hearing where the city attorney's office had an unlimited number of hours to give to this hearing, as well as provided and brought in a number of officials in to testify against me without much information. So, for instance, I came in at 9 o'clock one morning to face the fire marshal that I had to cross-examine. I came in and I had to cross-examine several members of planning, code compliance, and building and safety. There was a huge amount of evidence presented in this case. The hearing officer had to comb through volumes, and she came to this conclusion, and yet after this was over, the city attorney's office chose to present new evidence. This is my consideration, a second bite at the apple. In fact, I submitted an email saying it is a third bite at the apple, because as the staff attorney mentioned to you, the city or the landlord has already utilized the method, I'm not sure what it's called again, but the method of going through the hearings process to actually say we have rectified issues. So not only do they have a 2.5-year period of time, unlimited number of legal hours to present their case, they also went through the hearing officer's regular process to overturn things, and now here they are coming before you. Third bite at the apple, and not providing me with an opportunity to fight back, to provide witnesses, to provide information, and to in fact tell you reasons why all of the things they say are not in fact true. They eliminated on-site management, for instance, and yet they have now designated a resident as an emergency monitor, paying him $100 a month to be there in case of earthquake or fire. And yet whenever, so beforehand we had a resident manager, now we have someone from 8 to 5. Any time outside of 8 a.m. to 5 p.m. Monday through Friday, we are referred to an 800 number of the management company. We are not referred to their on-site emergency monitor. And this is what they're saying is a substitute for an on-site manager, but it is not. This person does not provide those services. So the fact is that they are providing you with quite a bit of information that is just plain false without giving me the opportunity of proving that it is just plain false. And the fact is that after 2.5 years of hearings, with no lawyer, me facing the city attorney's office and a number of officials from the city of Santa Monica, I won this case. I won it more than twice as much of what they ever had offered me. And because I was right and because they were wrong, and yet still here they are trying to use their authority to knock me down because they know that they're in the wrong and they want to cover it up. And it's just not conducive to the Santa Monica rent control law. It's not conducive to, I had people in there from 1973, 74, 75. I had multiple people from the 1970s testify. I proved a lot of things that were going on in the 1970s, and they had nothing to say about that, but they had no problem bringing in numerous officials that I had to cross-examine and fight against. And here they are again, once again, in front of you, spending taxpayer dollars to fight against $83 a month. It's not a reasonable question. They shouldn't be here. It's a third bite at the apple, and it's completely unreasonable. I could go on and testify about some of the other things they've asked for, but I really don't need to, because they just plain didn't provide me an opportunity to have witnesses and to provide evidence about them. They just made assertions, said things were this way, and expect you to accept them and overturn the hearing officer. The hearing officer spent 2.5 years in hearings. She went through volumes of work, and we should throw away her decision because the city attorney's office has plenty of free time on its hands. It's not reasonable. It's not fair, and we're talking about $83. How much taxpayer dollars did they spend in 2.5 years of fighting me? How much? How much do we think? $83 a month times, say, 5-10 years, we're talking about a couple $1,000s. And they spent tens of thousands, if not more than $100,000 of taxpayer dollars to fight me. And here they are again doing it. This is a violation of due process and a really sickening waste of taxpayer dollars when we are in a place where people don't have homes and the economy is terrible, people don't have jobs. And I'd like to just finish this off by saying there's a huge amount of light on municipal government in California at this time. We've seen LA Times articles about really unfortunate cities and municipalities behaving in really, really terrible ways. And unfortunately, I think the city attorney's office in Santa Monica thinks they can do the same in this case. Don't allow them to. We need to remain above board. We need to do what's right, and we need to uphold the hearing examiner's work of 2.5 years and a huge amount of testimony and witnesses. I appreciate your time. One more thing. Sorry, I want to say this. I also want to say that I appreciate this new letter we got about the annual adjustment. This is the first time in the 16 years I've lived at the mobile home park that I see a document that really addresses the mobile home residency law, is specific to mobile home parks, talks about space rent, talks about the rights of mobile home owners, different than apartment owners. And I really would like to say that I appreciate the Rent Control Board and the Rent Control Office's recognition of the certain kind of a special situation one is in when one rents just a space and one owns a mobile home. So I just want to thank you for that. Thank you for listening.
Thank you. I think commissioners may have some questions for you, Linda. Commissioner.
Estimate of how many hours in the aggregate the hearing took?
Sorry, the hearing took? Well, we did have a delay of approximately 4 to 6 months because the city was undergoing an infrastructure upgrade of the property at that time.
I'm asking a different question.
Okay.
In other words,
The actual hearing hours.
yeah, how many hours were you on the record or off the record, but the hearing was going on, if you had to estimate?
Is it possible you have the number of days of the hearing right there? Because 8 hearings. 8 hearings from 9 a.m. usually to 4 p.m. So however long that is, that's a number of hours of
Thank you.
information.
Commissioner Carnovet?
Commissioner Flora was ahead of me, sir.
Oh, sorry, I didn't see that.
I don't have a question for her.
Okay. Yeah, we'll finish with her and then on Dick.
I would like to just make a quick comment that your courage and bravery is a great value. To fight a giant is a terrific thing. I'm sensitive to that. Have you had other landlords outside of the city of Santa Monica before this?
Oh yes, I lived in 4 different mobile home parks, and my parents own a 36-acre mobile home park, so I've had a lot of experience there. Before that, I lived in different rentals, so I've been around. But my vast majority of my experience since, I believe, February of 1989, I have lived in a mobile home park.
And last question.
And 16 years here.
Yeah, I'm very familiar with this particular park. Since the city took it over, can you share with us, if it's prevalent, Mr. Chairman, how things have changed? Or is it inappropriate to discuss that? That's not relevant? Okay. You're a brave lady. Thank you so much.
All I can say is it's gotten worse, and our management is terrible, and we would really like to see a change in the people who are at housing, who don't seem to think that people who own mobile homes have any rights more than a low-income housing resident. It's unfortunate. Any other questions? Sure.
I believe that's it. Thank you
All
very
right,
much.
thank you.
Commissioner Flora, you had a comment about the case?
I do. If I could ask the staff attorneys, if there is a more appropriate venue for correcting these through the confirmation compliance process, why is it that they're being allowed to appeal? Why don't we turn that away and say, no, go through the compliance and confirmation process? It's wasting everyone's time not to.
Well, it is a legal process, and therefore they have the right to do that, as any interested party would. Any landlord or any tenant has the right to bring the appeal under the law to you, and that's what I can say about that. We cannot. There's no authority for us to turn around and tell any specific party that they don't have the right to appeal and bring a matter before the board.
Okay, I'm not talking about taking away rights, but it's not as if we're not giving them a venue by which they can, get their increase back for the fixes they make. And I want to know, are we allowed to say, hey, you have this option also, you don't need to set an appeal? If not, why not? Because everyone's time is being wasted here, I think, under the guise of rights.
When a party, particularly a landlord, files an appeal, and the nature of the appeal seems to be more along the lines of, I have now fixed those things, staff does let them know that there is a process in which they can have decreases reinstated if they can establish that they have in fact reinstated those services. And so we have done that in this case, and we have done it in other cases as well.
And last question, Mr. Chair, in your opinion, are they abusing this process to drag things along, and are they misusing this process in your opinion?
Commissioners, I will defer to you to make that judgment. My judgment here is, my responsibility here is to just advise you with regards to the law.
Okay, thank you.
May I comment, Mr. Chairman, on his question? Or shall I wait?
Commissioner Winslow had his
sir.
before you, and then you, and then Commissioner Craig Wilson. I'm not sure which one of you, but
Of course.
he was there.
Was I? Okay. Well, I gather no one from the city is here to address this. Well, I'll put it this way. If someone were here from the city, I think that he or she would owe us quite a lengthy and persuasive explanation why 2.5 years wasn't enough time to marshal and put before the hearing officer whatever evidence they had. That's a recipe for breaking down every administrative and judicial process in the country. If a party litigant can have that many that many days in hearing, and then want to bring in new evidence after the hearing has come to a close, it just won't work. So, unless I'll offer an answer to your question. Unless I hear something very different from the other side, and they haven't taken their best opportunity, which is here in this open forum, I'm going to assume that it was an abuse. All that time, all that energy, all that, because that's money. All that time, and then to offer new evidence. Anybody should understand, hey, we had our chance to put on our case.
Commissioner Cronovette?
Well, I suppose it comes down to a very simple principle, really. As elected officials, are we here to stand up for the individual, or are we here to stand up for the bureaucracy? I favor what Commissioner Winslow said and Commissioner Flora said, that it is absolutely a municipal abuse of power. You have been abused. You have been stepped on. You have been subjected to corruption. I have seen it for many years, and your bravery is of a great value. I believe it's our job as elected officials to step and push back, and that's what we're going to make an effort to do here. To have an individual subjected to 2.5 years of a $25 million, 44-staff budget at the city attorney's office for an individual is a complete abuse of power, publicly seen. Will it change? Possibly. At this moment, though, this particular body has a chance to make a statement. So when we're done, Mr. Chairman, I'm prepared to vote.
Any other comments or a motion that anyone wants to give? Commissioner Flora?
Thank you, Commissioner. I certainly move to uphold the hearing officer's report.
Second.
Before we vote, was there any other comments that wanted to be made? If hearing none, if we could get a roll call vote, Lima.
Commissioners Wilson.
Yes.
Commissioner Winslow.
Yes.
Commissioner Cronovette.
Yes.
Commissioner Flora.
Yes.
Commissioner Brown.
Yes.
Motion carries.
Thank you.